How can intellectual property be enforced internationally? In recent days, the topic of enforcing intellectual property rights across borders has gained significant attention. As businesses expand globally, the need for clear strategies to protect intellectual property has never been more pressing. Viewers may be searching for ways to safeguard their creations in an increasingly interconnected world. So, how can rights holders ensure their intellectual property is protected internationally? Enforcing intellectual property rights involves navigating a complex legal landscape. Each country has its own laws and regulations, making it essential for rights holders to be informed. One effective method is through customs and border measures. Rights holders can apply for actions that allow customs authorities to detain or seize goods suspected of infringing intellectual property rights. For instance, in the United Kingdom, an application for action can be submitted to Border Force to stop counterfeit or infringing products from entering or leaving the country. Similar procedures exist within the European Union, where applications must be made through the Customs Department of a member state. National enforcement remains a key aspect of intellectual property protection. Rights must be enforced through national courts in each country where infringement occurs. Even European Union trademarks are enforced by national courts, not a unified court. However, the Brussels IBIS regulation helps in recognizing and enforcing judgments across European Union countries. This means decisions made in one member state can be enforced in others, streamlining the process for rights holders. International treaties also play a vital role in intellectual property enforcement. The Agreement on Trade-Related Aspects of Intellectual Property Rights, under the World Trade Organization, sets minimum standards for protection and dispute resolution. This encourages member countries to enforce rights consistently, creating a more reliable environment for businesses. In the digital age, online platform regulations are becoming increasingly important. Recent legislation, such as the European Union's Digital Services Act, introduces standardized procedures for online intermediaries to handle intellectual property infringement claims. Rights holders can file takedown notices through electronic portals accessible across jurisdictions. Platforms are required to respond promptly, either by removing infringing content or providing explanations for retaining it. This regulation also mandates that marketplaces verify trader identities and take action against repeat infringers. Government and institutional support can also aid in managing overseas intellectual property risks. Some countries, like China, have introduced policies that assist private enterprises in navigating international disputes. This includes setting up intellectual property contact points abroad and providing early warnings about foreign legal changes. In practice, enforcing intellectual property rights internationally requires a combination of legal filings, customs actions, court proceedings, and collaboration with online platforms and government bodies. Rights holders must be aware of specific procedures and laws in each jurisdiction. Coordinating multiple enforcement actions simultaneously may be necessary to protect their interests effectively. As businesses look to expand globally, understanding these mechanisms is essential for safeguarding their innovations.